Welcome back to the morning show. It's 11 minutes after 7 o'clock. Welcome to the second of our hour of our time together. It's so good to be with you. If you've just joined us, a very good morning to you. This is the morning show. We're with you all the way till 8:30 on ETV. Now, a little bit earlier, we did tell you that we're going to have a conversation all things marriage. Now, here's a question to kickstart the conversation. Did you know the legal consequences flowing from your marriage contract affect your estate structuring, tax obligations, maintenance obligations, debt, and so much more? Yeah, if you didn't know, well, you are at the right place, because we're joined by legal expert Lethabo Mashishi to give us more of an understanding of marriage contracts and protecting your interests. Good morning, Lethabo. Thank you so much for joining us right here on the morning show.
Hey, movie, sure.
Lethabo, maybe let's start. First things first. You know, we're going to be talking about quite a number of things. So maybe let's understand the different, how can I say, property regimes when it comes to matrimony, the in-accrual and outside of community. It sounds like there's so many different things. But for someone who doesn't understand, could you maybe explain each to us that we have in South Africa?
Well, in South Africa, we have different types of marital regimes that are applicable in our law. We've got what we know as marriages in community of property and marriages out of community of property. Now, with regards to the two, the distinction lies in the fact that one requires the registration of what is known as an antinuptial contract before the marriage is concluded or entered into. Now, a marriage out of community or property basically requires that before the parties can enter into that marriage, they must firstly execute an antenuptial contract prior to the conclusion of their marriage, and that contract must be registered in the relevant deeds office within a certain period in order for their marriage to be regarded as one out of communal property. Whereas a marriage in communal property does not require the registration of any antenuptial contract.
So maybe to make it make sense, because many times when we're speaking about the in community, out of community, the main thing that people always say to understand this more is the 50-50, or what's yours is yours, what's mine is mine. Which would be falling into which here?
Right. So with regards to marriages in communal property, basically states that the parties' estates are joined and one estate is created wherein they equally share in the assets and liabilities of that estate. So that is where the 50-50 type of marriages comes in when it comes to a marriage in community of property. However, with a marriage out of community of property, we have what we know, what is called the accrual system, wherein parties are at liberty to get married out of community of property with or without the accrual system. Now, the distinction between the two lies in the fact that where parties are married out of community of property without the accrual system, it basically means that there is no sharing of assets at the dissolution of their marriage. But if the accrual system is applicable to that particular marriage, it means that the spouse or the partner whose estate has shown an increase at the dissolution of the marriage will be required to share a certain portion of their estate to the spouse whose estate has not accrued at all.
Okay. And this is something that we've heard also come up in conversations many times leading up to the marriage. Now, something that is interesting to note is that community of property seems to be the default regime in South Africa. Why is that the case, or is this something that is standard around the world?
Well, it's not necessarily standard. I mean, it's one of the things, maybe it could be due to, I suppose, lack of knowledge, in that perhaps parties are not aware that they can actually enter into what is known as an antenuptial contract in order for their marriages to be out of communal property. Or sometimes it so happens that people are of the view that because they've executed an antenuptial contract, that it would mean that their marriage is out of communal property. As I mentioned earlier, the antenuptial contract that the parties enter into, it must be registered within a certain period. In terms of our law, in South Africa, where a contract has been executed in South Africa, it needs to be registered in the deeds office within 3 months from the date that it has been executed. But if it's a contract that was executed abroad but to be registered in South Africa, it has to be registered within 6 months from the date of execution.
Now, let's talk about...
So if you have...
Sorry, please carry on.
Apologies. I was about to say, if you have now a scenario where parties did conclude an antenuptial contract before entering into a marriage. However, that contract was only registered 4 months after it has been executed. That marriage will be a marriage in community of property. So the time frame is very, very important.
Okay. This is where it gets interesting. But how does one then decide? Because I think, again, societal conversations that we have specifically about this is not understanding the implications that we were talking about at the beginning, talking about maintenance obligations, debt, and etc., many other things. How does one then decide which regime to choose outside of the common culture, speaking of, rather take in community or out of community because of the 50-50 or what's yours is yours, what's mine is mine conversation with a little bit more insight? How does one get to actually choose which one works for them?
Well, look, that one is quite subjective. I mean, it'll boil down to the interest that the parties have and the communication that needs to exist between the two of them in deciding what would work, what would best work for the both of them. I mean, it's not a situation where there is one perfect system that would necessarily apply to everyone. It depends on the circumstances of the parties and what they consider to be fit for them. Obviously, each marital regime, it has its own consequences that they would need to be aware of before entering into before deciding which marital regime to actually choose.
100%.
Now, to get a better understanding before one makes that type of a decision, I would advise that perhaps a consultation be made with a legal expert on marriages so that they can be well informed when they make that decision in terms of which regime to use.
Lethabo, thank you so much for your insight. We're going to pause the conversation over here only for a little bit, and then we'll continue the conversation just after the break, where we'll talk about various other things, talking about fat and sit, talking about lobola, talking about what happens when you realize you might have just made the wrong decision about the type of regime to get into. So stay with us. We'll be right back just after this. All right, welcome back to the morning show. It's 22 minutes after 7 o'clock right here on ETV. We continue our conversation with Lethabo Mashishi, a legal expert in marital contracts. And in the first segment, he explained the different matrimonial property regimes that we have in South Africa. And there's still so much more that we're going to continue the conversation about. Lethabo, before we continue, maybe you could give us a very brief recap of the two differences, in community, out of community, and what that basically means, because I think it's going to be crucial for where we're going with this conversation from here onwards.
Yes, no, not a problem. So a marriage in community of property essentially means that the parties to that marriage, they have one estate, one joint estate, wherein the assets and the liabilities that flow from that estate are equally shared amongst the parties. Whereas a marriage out of community of property, each party has their own respective estates. However, there is a further distinction when it comes to marriages out of community of property, wherein the actual system is taken into account. A marriage can be out of community of property with the actual system or without the actual system. If it is a marriage out of community of property without the actual system, that basically means that there is no sharing at all at the dissolution of the marriage. A marriage out of community of property with the actual system means that at the dissolution of the marriage, the spouse whose estate has shown an increase or a growth may be required to share a certain portion of their estate with the spouse whose estate has not shown any accumulation or growth at all.
Okay, now let's step into this. So now we saw over the last couple of days, news that were making headlines was after the passing of DJ Somebody, his girlfriend and the family of DJ Somebody kicking her out of their house that they've been together for quite a number of years, over 10 years that they've been together, not married or anything showing, allegedly so, that they weren't married. In situations like that, and what we would call fat and sit, are there any implications for those people who've been living together for many years and are still unmarried? Do they fall into any regime, or is this one of those where it doesn't actually hold any water contractually?
Well, I'm not entirely familiar with all the facts surrounding that particular case. However, in terms of our law, in order for one to receive certain benefits, there has to be, especially in a matrimonial setup, there has to be a marriage that has been concluded between the parties. However, if it was a situation, as you've indicated, offered and said, for instance, but during the continuation of that relationship, there are certain contributions that one has made to the growth of the estate of the other party. That is something that can be challenged in a court of law to see if there is any form of claim or compensation that the surviving partner might be able to receive out of the estate of the deceased.
Okay. And what about in situations where, someone has just paid lobola and there's nothing other than that? They've just had the meeting where they managed to pay. There hasn't been a celebration as yet. Can one just walk away without any implications that they can expect on their marital connectedness, so to say, and any contractual obligations that they may have?
With regards to payment of lobola, basically now are dealing with customary marriages. There is quite a bit of a gray area with regards to that. Look, there are requirements that are set out in terms of the Recognition of Customary Marriages Act. That basically states that the parties must be of the consenting age, which is 18. The marriage must be negotiated, must be entered into and celebrated. Those are basically just the requirement. However, there is a lot that can be done in those type of marriages. For instance, what you've indicated that only lobola was perhaps paid. What then happens in that instance? There's been numerous case laws dealing with the situations such as this where only lobola was paid, but there are other factors that the court had to consider, such as whether these people were living together or not at the time of the dissolution of the marriage, or perhaps at the time that one of them passes away. And it got to a point where the court are now starting to sort of relax the requirements in terms of the application, obviously looking at the facts of each case that is before the court. So even if one were to have paid only lobola, but there were other things that were done, if there are other factors that the court will consider, those would be taken into account in determining whether a marriage was concluded or not. So it's not entirely to say that if only lobola was paid and the other requirements, the other traditional ceremonies were not done, it means that the parties were not married. As I indicated, there has been numerous instances or case laws wherein lobola was paid, or even half of the lobola was paid, but there are other external factors that the court had to consider in determining whether there is a marriage that was entered into or not.
All right. Now, Lethabo, we've spoken about various other situations and the contractual obligations with the different regimes. Now, for someone who's listening to the conversation right now and realizing that, oh my goodness, I may have been ill-informed or uninformed about the differences and what it would mean to me and my marriage and the obligations thereof, and I'm realizing I may have made a mistake, I may have made the wrong choice as to what type of regime to get into. Is one able to make a change in that situation?
In terms of the marital regime that they've entered into?
The marital regime they may have entered into. So you did mention earlier that the default one is in community. So for someone who's maybe listening, realizing that they would have loved to be out of community, or they're already out of community, but their standard chose with accrual and they would have loved to be out without accrual, or vice versa. For someone who now realizes that they've made an uninformed or ill-informed decision, are they able to change it?
Yes, 100%. So the Matrimonial Property Act, which regulates the various marital regimes in South Africa, does provide for instances such as that, where the parties can approach a court of law to request that their current marital regime be amended or changed to whatever regime that they would want to enter into. So it is very much possible that parties can seek legal advice, and based on the legal advice that they would have received, approach a court of law in order to change their marital regime.
All right, fantastic. Lethabo, thank you so much for your time and for making time to explain this to us even further and enlightening us on those topics. It's Lethabo Mashishi, legal expert, encouraging us to know a little bit more when it comes to marriage contracts, understanding what are some of the things to look out for. And more importantly, maybe this conversation has enlightened you before you get married, or even if you've already been married, that there is an option for you to seek legal advice and make a better decision from there. Stay with us. Your news are coming up next.